We're with David Shapiro. David is a criminal defense attorney in San Diego, California. He's agreed to answer some online questions related to conspiracy. These were posted online, and with that said, David, let's go into the first question that was asked of you. My son was arrested and is being held. I plan on bonding him out, but I don't even know what one of the charges is. What is a conspiracy charge?
Well, a lot of times conspiracy charge is filed, obviously, when you're dealing with a substantive offense and then a conspiracy to commit that offense as well. A lot of times, particularly if you're in the process of bailing your son out of custody, police agencies will bail someone or book someone, actually, I'm sorry, on a conspiracy charge as well as the substantive charge. It's weird. Sometimes you see it on DUI and then conspiracy to commit DUI. Well, if they committed DUI, it is what it is. But they do that for a couple of reasons. One is because they may be trained to do it that way, law enforcement to book people in, and the second is to raise the bail. Generally speaking, conspiracy is an agreement with one or with more than one person to do a certain act, and something is done in furtherance of that act. An overt act, it's referred to as. So, it's a pretty confusing area of law. A lot of attorneys don't understand it too well. It's hard to explain, but it generally is when you have a situation where more than one person's involved and there's some sort of an agreement and an act in furtherance in trying to accomplish what the act was.
Okay, next question is, I've been charged with multiple felonies and conspiracy. What are the first steps in attempting to get this resolved?
Well, the first step is, keep your mouth closed. If you're contacted by law enforcement or an investigator or someone who wants to discuss the matter with you, certainly keep your mouth closed as far as communication with co-defendants. You need to be mindful of these things. A lot of times in conspiracy cases, these cases unravel once you go on someone's Facebook page, and the defense might be, hey, those people never knew each other, or my client didn't know anybody, and there they are on social network, or there they are seen hanging out together, there they are seen getting arrested together on unrelated cases, those types of things. So the first thing you want to do is keep your mouth closed. Make sure you don't give the prosecutor any more evidence than they might already have. You can't really go ahead and start destroying evidence, so to speak, but you can certainly be mindful what you post on social networking, on the internet. Be careful who you speak to, who you're seen with, and make sure you hire yourself a good attorney, an attorney who's experienced in defending against conspiracy charges and the substantive offenses that go along with the conspiracy.
Okay, next question we had is, I don't even know several of my co-defendants. How can I be charged with the same conspiracy?
Well, here's the thing. You only really need to know one, and they can infer that either directly or they can infer that circumstantially. What I mean by that is that, they could say defendant 1 knows defendant 3, or they could say defendant 1 knows somebody who knows defendant 3, and that's sort of the link, even if their link is not in the conspiracy. It's kind of weird. It's really hard to understand. I'm representing someone in a conspiracy right now who doesn't really know anybody, who's charged in a conspiracy. And a link is someone who's not even charged. The link that the prosecution's alleging between my client and the rest of the conspiracy, that person's not even charged, and it's a tenuous link at best. So, you don't have to know everyone in the conspiracy. You only have to know one person. And the issue is how the prosecutor is going to be able to prove that through direct or circumstantial evidence. And if it's circumstantial evidence, how strong or weak that circumstantial evidence is.
Okay. And the final question we had is, will I be responsible for to make payments on behalf of the other members of my conspiracy?
That's a good question. That's a problem a lot of times when you're trying to resolve these cases, because generally speaking, if you're part of a conspiracy and assuming there's a loss to a designated victim, so to speak, the problem is that you may be on the hook for the entire loss if you're convicted of the conspiracy. So say, for an example, me, you, and a third person are part of a conspiracy, and that conspiracy causes someone to lose $400,000. Well, I may be individually responsible for, say, $20,000. You may be individually responsible for, say, $20,000. And then the other person will be on the balance for that multi-$100,000 individually. However, collectively, if you go down on the conspiracy charge, you're going to be on the hook for all of it, joint and severally liable with your co-defendants. What that means is that we're all kind of on the hook for the total amount, and we can divide it up as we see fit. But if one person doesn't pay their part and we're short the total amount, we're all short that total amount. So restitution is a big issue in trying to resolve these cases. And it's also a big risk, because a lot of times the prosecutor knows that, and what they'll do is make you an offer that may not be the greatest offer in the world, but it would be to dismiss the conspiracy charge. thus alleviating any concerns you may have about being on the hook for an exorbitant amount of restitution. So that's something you need to consider as well. Restitution, and your attorney should be keeping in mind, hey, is that a factor? Is that an important factor for my client moving forward? And how does that reflect, or how does that reconcile with what we're trying to accomplish here? Is it get out of this with the least amount of damage, the least amount of restitution, the best deal, a combination of all three? What are the risks and the costs associated with fighting a case on? And particularly if you were to reject an offer, or if you were to take the case all the way to trial, is that client prepared for the consequences and the risks associated with that? A lot of times, attorneys don't know enough, and they can't give their clients all that information. The goal is, as an attorney, your attorney should be giving you that information to make sure you make a decision what's best in your interest, what you believe is in your best interest. So, that's something to keep in mind. You might wind up being on the hook for everything, but you have to be convicted in the first place. And hopefully the state of the evidence doesn't support a conviction. And even if it does, hopefully you have a good enough attorney on your side that could do something about that.
Excellent. Well, if you have any other additional questions for David, all you need to do is post them to the comments section below. He's agreed to answer some direct questions. Basically, you just post them and he'll get back to you typically within about 48 hours. With that said, David, thanks for your time.
Yeah, my pleasure. The key thing with conspiracy stuff is it's confusing. It's confusing for a lot of attorneys. I get confused with it from time to time, but don't be intimidated by it, and don't throw up your hands and throw in the towel. There's a lot of stuff that can be done on these types of cases, because it's complicated to understand, it's also complicated to prove sometimes. That makes it difficult for the prosecution to get convictions.
Excellent. Thanks, David.
Take care.